we go. Oh, there we are. Okay. Hello, everybody. Hello. welcome in. Got a little bonus tonight. A bonus live for ya. Hopefully everyone's doing okay. Hello, Sylvia. Good to see you. Hi, Vicky. Hello. Hi, Sherry. Hi, Deb. Hello, Willie B. Hello. Well, welcome in, everyone. I wanted to do just a little bonus live tonight. I am so behind in annotating all of the things that have been coming out, so I thought I'll just turn the camera on when I'm annotating here. So, oh, thanks, Mary. Thank you so much. I appreciate that. Hello, Dee. Hello, Sally. Yes. Oh, thank you. Thank you so much. Yeah, they're hopefully not too reflective, but it was kind of fun. It's for some fun tonight. I hadn't really planned to go live tonight, but I thought, well, I'll go ahead. Mel Bovee is going to be a judge. Oh my gosh, really? Where? Where is he going to be appointed a federal judge? Love the ring. Oh, thanks. Thank you so much. These are for fun, so I think that's important. Oh, of course, Andrea, of course. Oh, I've picked up my rings just kind of all over the place over the years. So, little shops here and there. And sometimes when I've been abroad or, around, so there's no specific place. Even a couple of them I've been able to get off of Amazon. So, they're just kind of all over the place. Hello, Kaya. Hello, appellate. Okay. Appellate judge. All right, so I'll let you all in on a little secret here. So one of the okay, I'm sorry. So one of the kind of like secrets that a lot of people probably don't know unless they're in the legal field is that one of the ways, if we've got an attorney that's in the field that we have to work with and they're like they're kind of jerks and you don't really want to work with them. And everybody kind of feels that way. And you know what I'm talking about, right? Just kind of that one attorney that just is like, oh my gosh, this person, I'm just going to scream if he's opposing counsel again. So what we would do, the bar association, is that we would kind of on the down low nominate them to be the judge. If there's a judicial nomination up, we'd be like, hey, we got the perfect person. So we'd all nominate him and then we would email, everybody else. We're like, hey, this guy. And they're like, oh my gosh, he's awful. We're like, yeah, let's make him a judge. And so if they got all the votes. Now, if they want to stay in the position, they got to do their job. But it's just a lot easier to actually go through the process when you're not dealing with Now, you might say, well, then you get a crappy judge on the bench. But what's nice about that is, if they screw up, they have another court that will keep them in check. So a full court to come in and be like, well, that's wrong. And we appreciate that. So yes, Lynn, yes, that's kind of a little secret. So now some attorneys may say that's not how we do it, but that's how we do it here in my neck of the woods. Have you ever seen a judge fall asleep? Yes, I've seen judges fall asleep. Many times the appellate judges, so if you've got a 3-judge panel or if you're arguing in front of your state Supreme Court, and it's like oral argument day and there's multiple oral arguments going, yeah, they'll fall asleep. I've seen a few of them fall asleep before, so that's okay. Nope, just getting started. Yeah, they're now subject to review. Exactly, Vicky, exactly. So again, and that's, I'm not saying we do that every time because honestly, there just aren't, in my area, there just aren't that many, jerks that we would want to get rid of. We would just, if we find one though, we corner them and nominate them in the committee. But then we also have some people that are like, oh my gosh, this person is amazing. We got to get him on the bench or her on the bench. So there's plenty of those as well. But just heads up on that. They're just human. Oh, exactly, Vicky. Exactly. You got out of jury duty, Cynthia. Oh my gosh, that's not easy to do. Hello, Katie. Yeah, that's not easy to do. It can be difficult. It's hard to get enough people to come in to do a trial. People don't seem to like missing work and not getting paid for days on end. I don't know why, but yeah. OCG to bring him back to the States. Oh my gosh, Willie B. Oh my gosh, I tell you, in that particular situation, because of where he's currently located, it would absolutely be possible. That would probably be the easiest out of everyone to get back over here. Although the sixth headed to South Sudan, which again, I'm not sure exactly where they're at, where their location is. They may also be the next batch that are easier to get back. But yeah, I'm good for 3 years. Oh, that's fabulous. That's because you just worked so hard. You put your time in. Oh, thank you so much for your service. We appreciate that. Always excused from juries, even when I try hard to stay. Well, that's the thing. Like, we know you're trying to stay. And if we get that vibe off of someone, we're like, ooh, we don't want leaders, all right? When we're picking a jury, we don't want leaders. And you might say, well, that doesn't seem right. But here's the deal. We want everyone to be on equal footing with each other. We don't want anyone to come in and just start directing the jury. You know what I mean? We want everyone to be right in the middle, plain vanilla ideologies, just like right down the middle of the road. We don't want someone that's clearly, an advocate or is anti-advocate. We just want everyone to be as plain as possible. I might start talking about jury nullification. Wow. Well, yeah, that's not great either. Jury nullification should be that unicorn that every once in a while might come out when there's a really atrocious law being used. But on the regular, if it's just like, an OWI case, like, why are we nullifying our jury? Like, everybody agreed this was going to be, don't do this when you're driving. They're like, well, we don't like the law. So we get in trouble with that. Oh, hello. Yes, thank you. Well, come on in, W. Moi. That's what I will be kind of doing tonight a little bit, is I'll be going through my process of annotating with everyone tonight. Because I think it's, it's something that I do, and it helps to do a legal analysis when you can pull the pieces apart like a puzzle. And for me, visually, it really helps a lot to do that. Yes, well, we thank you for your service already, White Collar. Appreciate it. Do I change them every day? I do. Well, or every couple days, even sometimes a couple times a day. Like I had my cherry nails this morning, but I was like, I'm done with the cherry, so let's have some fun. I wasn't planning on going live tonight, so these would not be what I would call my going live nails. These are kind of my fun nails, but whatever. So that I would just turn my camera on here. Came close, but they let me go. So that's a good question. Do we want people who are highly educated on our juries? And I would say it doesn't. It's going to depend on the case. There's not really, we don't typically try to get someone off of a jury because they're at a master's or a PhD or doctorate level. Like, that's not typically one of the reasons why we would strike someone. But it just depends on the responses. There are plenty of people who are incredibly highly educated that are just even keel, middle of the road, which is what we're looking for, and they just are great on juries. And then there have been other people who just do not have any higher education, which of course you don't need to always have. And they have been too aggressive, way too aggressive and too dominant. So in those situations, we would absolutely take the person with more education than the other. It really has to do with being in the middle of the road there. Final year in law school. Oh, great. Oh, I'm so glad. I'm so glad. Oh, the last year's the tough one. I mean, they're all tough, but yay, you're making it through. Was picked for, okay, yeah. I think it really just depends on how you're presenting. And not only that, not all prosecutors, not all defense counsel do this, but before we even start going through and asking questions, we're watching you. Like everyone kind of comes into the courtroom and, kind of waits until everything starts. And you'll see attorneys go out into the hall and walk around and, because we're watching you and we're already taking notes as soon as we see you. Like this person was sitting by themselves off in the corner. This person was getting very upset with someone. This person was listening to music. This person just was being chill and hanging out. Like we're already making notes about each different person. So that's something that happens too. So it's a lot of things that we put together. Do they do background checks on juries? So that's a great question. And no, a criminal background check is not something that should be done unless somebody writes in there they've been convicted of something. And then you might go and say, well, do we have enough information? Or you may ask them for more information about it. But the kind of background check that you would do is what the public can have access to as well. Like there's no special background checking that the prosecutors or the government gets, right? So when you do a background check, when police are pulling you over or whatever, it's not like that. It's not that detailed. And it really doesn't even need to be anymore these days, because I'm so old, everybody. But these days, like all you got to do is pull up social media and it's like, boom, their entire life story is there. Yes, feel free to DM me. I do have my DMs open. And there's nothing wrong with being in a corner by yourself. There's nothing wrong with that. We just note it. And again, depending on what kind of case, is it civil, is it criminal, is it products liability versus permanent disability, is it a homicide case versus lower level DRUG case. So every case will have its own factors included in it. And so all of these we just watch and observe in order to pick the best jury that we can get. What do I look for? It depends on the case. It really depends on the case. I mean, the whole process of picking a jury, it's a process of elimination rather than a process of, actively choosing someone. And, we kind of went through this with Trump's trial in New York. The fact that certain people would give you extra information, that's where you're like, I don't want that, rather than I want this, this, and this. So it's more of a striking situation than a choosing situation. So it makes it a bit easier that way. Amber, I have closed my practice. And so I don't take clients anymore. I kind of wound it down. And I'm not teaching right now. I'm sabbatical in my mind. I'm no longer in the classroom, but just come here and hang out here. So that's where I go. Attorneys have numbers for each person. Yeah. Oh, absolutely. And usually there's a jury questionnaire everyone has to fill out, right? So once you fill out that questionnaire, it's got basic questions. Typically both sides need to agree to those questions, or there's just like a, garden variety, plain vanilla, run-of-the-mill form. And it'll have like, where do you work? What's your school? Are you, how long have you been living there? How long have you been, just very basic questions. How old are you? Those kinds of things. Are you good? Do you like police or not? Oh, thanks, Bryce Mom. Oh, I enjoy it. I enjoy it. This is so much fun for me to come and hang out because, the people that come by are really interested, You're not like, "Well, I have to take this class in order to get, my degree that I'm working towards." So this is more like, hey, people are more interested. Oh my gosh. Yes, I love it. I love it. How do you sign a document if you can't sign your name? So that's a good question. And, you don't, your signature doesn't have to be your name. There can be all kinds of different signatures as long as you are acknowledging that it's your signature. So some people can do an X, some people do like a couple of different symbols, like Prince, right? Bless him. Oh, Prince. Gone too soon. But anyway, as long as you are recognizing that this is a binding signature that you're using, it doesn't have to specifically be your name. Something that I've noticed too in some countries is they have like we know that there are seals, right? Seal rings for people who are like important, but then they also have like thumbprints, like you would put your thumbprint on there. And I'm like, why would you do that? I mean, are people checking thumbprints to make sure that it's the exact right thumbprint? But I don't know. There's just lots of different ways to do that. Yes, that's right, Corey. That's right. Yes, yes. Oh, of course, of course. Um, Yeah. So an X, I mean, again, you don't want to just be like, "Oh, look, it's an X." But if you think about it, and I would challenge everybody, think about any prescription that you get, right, where you actually see a signature. So go in online and look and see where the signatures are, or any kind of note from a doctor or whatever. And I'm using doctors because they're a great example. And quite frankly, or any law enforcement, quite frankly, I'm looking at you, law enforcement. You can't read what they're writing anyway. You really can't. You're like, is it Mike? No, my name is Gerald. Like you don't know what they're saying anyway. So as long as they're like, well, I'm acknowledging this is my signature. That's what you're really looking for. Really? Okay, in Japan. Yeah, I know there's several countries, multiple countries that have their own distinct way of, either some kind of a fingerprint or thumbprint or something like that. So I think that's really, really interesting. So yes, alternative dispute resolution is so very important. Like, hey, Gerald, exactly, exactly. So welcome in, everybody. I wanted to give a few minutes here for us to have everyone's notifications, pull them in. What I was hoping to do tonight, I am so behind here in annotating, and there's just been so many things going on. It's just really quick. So I thought I would just turn my camera on here, and I've got multiple different things. I've got an application to the U.S. Supreme Court. Here, I have a memo on a preliminary injunction here, so court order. I've got, what else do I have in here? Let me see if my pile of paperwork is the pile that never ends here. I've got declarations in here, so some court records filed, exhibits. Also, what else do I have? I've got some old school cases in here. So we can do some case briefing also as well. So there's just lots of different things. And depending on what it is, I have a different kind of annotating style for it in order to make it more user friendly. So I thought I would share that with everyone. It is Blue Horizon. It's definitely better today. I have to make sure I don't overdo it. But I usually overdo it. I've got to be. I remember, I had a vocal injury in college, and I was working at a law firm at the time. And I came in, and I couldn't barely talk. I wasn't supposed to talk at all, but I could kind of whisper. And I was like, dude, my voice. And they're like, okay, well, that's a bummer. I need you to go to the jail and see my client. And I was like, all right. So I drove over to the jail, and I was like on the telephone. I'm like, hello. I'm sorry. What? It was really bad. I got back to the office and I'm like, I'm gonna need to take a couple days off. Oh my gosh. Oh, I know. It's very difficult to keep up. It is, it is. Yes, it's a lot. There's a lot going on. So let me keep you updated as we go through this, and again, just to explain my process here. So the first thing I've got here is yes, in the budget bill. So prerogatizate. I have posted maybe 3 or 4 posts on that, and I just did another post today, this morning, on it, explaining it. So those will do a better job than my quick analysis here, but the long and short of it is just whether or not judges have to put a bond on preliminary injunction, which is discretionary based off of the rules, and they're trying to make it so it's not discretionary in that if you don't, then you can't use any kind of appropriated funds from Congress in order to enforce the preliminary injunction. See, that doesn't really make a lot of sense. You gotta go check the post out. Of course. This is a huge question. And everyone's asking, and I think it's wonderful. I think it's fantastic that everybody's asking it. All right, so here we go. Here's the first thing we're going to take a peek here at this is the DVD case, right? So this is the South Sudan case where, whatever, we're dealing with that. And there was an injunction put into place, right? So the judges said, look, you're not supposed to be doing this. You need to go and take care of business. And of course, they've appealed it. And they have appealed it at this point up to the U.S. Supreme Court. And so we're all just kind of waiting to see if the U.S. Supreme Court will take it or what. So this is the application, and it's the application by the government. So I thought, well, let's just go on in and thanks, Maria, and start to annotate it. So when I'm annotating, my colors are pretty much the same that I use. So I use highlighters because I'm a visual person, but I also will underline. Sometimes I'll do dots. So this is actually only in the last few years where I've started using some dots. If needed. So I've got lots of different techniques on what to do, but the easiest one is going to be highlighters. And these are clickable highlighters. And I have to say, if you're not annotating and briefing hundreds and hundreds of pages a day like me, I would say you don't need clickables because these dry out super quick. But for me, what happens is I use all the ink before it dries out. So for me, the clickables work really well. But I would not recommend that for a regular person who is normal. I would say, get you a regular highlighter. Don't get the clickables. Oh my gosh. All right. So next, I always, again, have my underlining that I do here as well. So there's lots of different things. So for tonight, I wanted to, because I want to show you different documents and how I go through and annotate them. I will be kind of quick here about doing it. So first off, you're gonna need a key, and you always have to make your key. I'll make it here so you all know what it is. And what happens is after you make your key and you put it on the title page or on a sticky or whatever, when you've been doing this for years and years and years and years and years, then you just know the order. So the order, you don't have to make a key because it's just in your brain. It's just, that's what it is, and that's how it goes. So each color will have a different purpose. And then what I also like to do is put an outline for them as well. So each of these will be a different piece that I will highlight depending on whatever it is. But then now I need to know Roman numerals, right? Because everything's in an outline format. So here we go. This is usually the format I use, but I like to just make sure in case I'm out of a color or something like that. Roy G. Biv. Okay. I like to just make sure I've got this in case I'm missing a color. Sometimes I'll have a purple highlighter in here, everybody, and that just throws everything off. The world goes crazy. That's right. That's right. Oh, exactly. Exactly right, Chris. Exactly. You bet. All right. So, and I'm trying to make sure that I say everything. When all of this is just in your head, sometimes, it's hard to make sure that you tell everybody everything. So this is the outline set. All right. This is important. This is very important because we're going to have Roman numerals, we're going to have letters, and then under that we're going to have numbers, and then we're going to have letters again, and then we're going to have numbers again, and then sometimes we'll go into the little eye area, and then if we're in the eye area, I'll decide in the moment. I'm just like flying by the seat of my pants if we get this far down. So this is the order that I do for the outline. But when it comes to the colors, this is what I use. Again, everyone can just kind of pick what you want. But I've been doing this for decades, so this is just kind of how it is for me. Usually, blue is going to be any law, like a code section, or the Constitution will be in blue, or if there's a law review article, that'll be in blue. Something along those lines. So any of this was a few days ago, VC. Yeah, this was a few days ago. So that's what I will have here for blue. So again, like that. Now, if there's actually an opinion, I would put dissent in blue if I had a dissent, but we don't have that here. This is an opinion, but no new order. No, I didn't see new order yet. All right, now for green, green's usually the facts. So if I've got wherever facts are set out or something that looks like facts, I will highlight those in green here. Next, pink. Pink's for precedent. So any cases, precedent, any cases that are cited in the entire thing, any cases, they will be highlighted in pink. Sometimes too, I will highlight parties in pink, although with all of these cases, I've had to color code the parties, so they're not in pink anymore. But anything also that's a direct quote from the court will also be in pink here. So again, this is just kind of my key that I use. So orange usually will be if there's a really critical holding piece. So if they're quoting a holding in a case, that will be one of the highlights in orange. Usually though, in motions like this, the orange is just part of my outline format. So it's not necessarily that big of a deal. And then the highlighter yellow are going to be any kind of keys. So any major keys to the case that are very important, I will put in yellow. Typically, I will then underline in red, means it's super important. If it's in blue, it usually means it's from the defendant. Or if it's in black, the black underline usually means it's the prosecutor. All right, so I have different underline colors that I use for the yellow. All right. Yeah, legal support. Yep, exactly. So, and I'll go through this and show everybody how I do this as we go through the process. Move the paper to the left. Sure, you bet. Can't see the outline. Sure, here you go. Let me see. How's that? Is that better? You just let me know. Yes, it'll be put up onto the tube of you for sure. Yeah. So I'm going to also just make a little cheat sheet down here so that I can keep this going as we go through. And I'm just going to put the color. Oh, I'm going to need, that's not the right one. Oh dear. Let me see here. Hold on. Let me see where I have my piece. And well, maybe we'll be able to do it. We'll see how it goes. Get you the stuff that Hawk uses to cross post. Yeah, I've been looking at that. I've been looking at it. I should probably do that. Here, I'm just going to make another one that I can move from page to page as we go through here, everyone. So just a quick second here as I set this out. Again, now, here we go. I've had so many people request, how to go about how to do the annotating. And so I thought, well, let's just take some time to do that. All right, so this is the order here. Again, kind of a rainbow order, and we'll flip the pages. Oh, thank you so much, MT. Appreciate that. Hello, Dolphin. All right, so here we go. Let's get started here. First off, so this is the United States, U.S. Supreme Court. So the Supreme Court's usually always pink. And then up here, we'll have a number when it gets assigned. I haven't checked to see what number's been assigned, but we have U.S. Department of Homeland Security versus DVD. So right now, if any of the parties are from the executive branch, then they're highlighted in orange, all right? So if you're orange, you're part of the executive branch right now, or you're part of Mr. Trump's world. And then usually the petitioner then would also be green or blue. We'll just use green here. So this is the person that originally brought the suit, and they brought him against the defendant. But because we're on an appeal, now we have the appellant here, all right? So appellant, and then we have the appellee here. So the apple is down here. All right. Yes. What color for lies? That's a good question. And it depends. It depends. Sometimes the red pen has to come out. All right, so we have an application for a stay of the injunction issued by the United States District Court for the District of Massachusetts. So I do like to note what jurisdiction we're in. We're in Massachusetts. And so then I would like to come over here and I check out my map and I look and see which circuit we're in. All right, so here's Massachusetts, one of those little East Coast situations over here. Oh, thanks, Amanda. I appreciate that. So we're in the First Circuit here. So just kind of keeping that in mind. Now we know where we're at. And I like to just make a note of that for any kind of procedural history. So we're in the First Circuit requesting an immediate administrative stay. So that's what this is all about, is requesting that. All right, so there's our first piece. Now, I do not go through and read when I am annotating. I just annotate as I go through it. So I will just walk you through how I do this, but not, actually reading word for word how it's going to go. So here we're already in our first outline format. So I've got my Roman numerals starting here. And then the first subcategory. So legal background, factual background, government's likely to succeed on the merits, whatever, lack jurisdiction, respondents' due process claims are meritless, and then the other factors support relief, and then conclusion. So just kind of setting up that table of contents right off the bat here. Oh my gosh, yes. Oh, honey buzz. Oh my goodness. Yes, my friends, yes. Here's the map. This is so helpful. This is so incredibly helpful because it's hard to know where everything is. Like if it's too far outside of my own circuit, I don't know what it is. So I'm like, okay. All right, so next up, we've got parties to the proceedings here. And that's just, again, how I go through. I'm just pulling out the big pieces. And then all of these cases are cited, so I'm not going to highlight them because they're just part of the related proceedings, or we would call this procedural history. Also, if you want to get specific about it, so procedural history is one of our briefing categories for case briefings. Yeah. No worries, Thomas. Yeah, the Ninth Circuit. Oh my goodness. I know it. All right, so here we go. First page, the application. So again, I'm not going to read it. I'm not going to read it word for word because I need to pull the pieces apart. So first off, I'm looking and I'm seeing, well, I've got Rule 23. A rule is going to be in blue. The All Writs Act here, let me guess, is it a mandamus? Probably. Oh my gosh. But they're basically just like inventing these new applications and stuff. All right, so we've got United States Code here. So that's going to be in blue. So I'm looking again. Any other rules? Any other laws? No. Any cases in here that are mentioned? No. The other thing that's been really important on any kind of an appellate filing is that the citation to the record below. And so if we've got a citation to that, I will pull that out in yellow just so that when I'm looking at it, I can tell where the citations are to the record below, the administrative record. All right. So that's it for this page. So, and I'm not even reading it. I'm just like, okay, all my categories are done. Then next, I'm going to come in here and I'm looking. I don't see any citations in here. I'm shocked. And or any rules in here. I do have a footnote. Sometimes I'll highlight the footnote. Sometimes I won't. Kind of just depends on my mood. And here it's looking like we have a test set out. We're all about the tests, right, in the legal field. Aliens illustrate the government's urgent and compelling interest in proceeding expeditiously with third country removals. 1, an alien convicted of armed robbery under a final order of removal for 26 years, who was convicted of an additional armed robbery and kidnapping after being ordered removed. And 2, an alien subject to final order of removal for 13 years, and so on. All right, so now I can see here what the different pieces are. And these are the criminal records of the people that were sent to the South Sudan. So he's just putting these, he's just illustrating what their criminal records are. So I would just highlight this in green because these are facts. These are criminal history facts. So I'm just going to pull them out. If we want any more information, any more facts, here I will know to go to the green section. I'll also just make a little note here that these are criminal histories as well. All right, and then down here, we've got another citation to the record. All right, so that's it for that. And then flip here. Now, back in, usually the first thing I will look for is the law. So we've got the law here, the code section here, and that's all we have. We don't have any other citations or other references in here. All right, so next page, here we've got a citation to the record below. So this is the DC docket and the citation for document 131 again. So those will be in yellow, again, the lower record here. And we're seeing, again, it's 51A, and then we're at notation 46. So we should be able to go backwards off of anything that is cited and find exactly what they're talking about. So this is how we check and make sure that what they're doing is correct, and sometimes it's really not. So, all right, and then we have more code sections, which is going to be in blue. All right, and then we're gonna flip over here. More code sections here. I'm gonna double check. And then down here again, I'm just pulling them out again visually so that I don't have to worry about it. When I go through and read this word for word, like I don't want to waste my eyes on stuff that isn't really relevant. Like these citations aren't relevant unless I want to know where the stuff is, then it's very relevant. But I don't want to waste my time on the stuff unless I need to. So here we go. Here's another one here, and then let's see if the record was quoted. Nope, it's not. Now we've got multiple code sections here. So those are going to be in blue again. I'm pulling these out. And, you know, one of the things that was very helpful for me in law school or before law school even, I did do a couple of speed reading courses just for funsies, just for fun, because I would read a lot of, I read a lot of novels actually, but I was like, dude, I need to read more novels, and now I have all this homework to do. So I took a speed reading class so that I could like whip through them really quick. And that was very helpful for me. It might not be helpful for you, but it was very helpful for me. All right, so now we've got case law. So this is precedent. All precedent is pink all the time. And I would say if you have no time, to brief your cases, if you have no time to annotate any filings, if you just don't have the time, the one thing I would recommend is getting one color and highlighting the cases. If that's the only thing you can do, then that is going to make it worth your time to do that. If nothing else to bring you can do, then that is going to make it worth your time to do that. If nothing else to break time and you don't really care about anything else, I would say just pull the cases out. All right, so again, we're in yellow because we're referring to the record below. And as a friendly reminder, of course, the district court is the trial court. That's where the evidence comes in and those kinds of things eventually. So all of our appellate courts just get the record. That's all they get. They make their decision based off of the record that's been sent to them, and the filings and the briefs and the amicus briefs. All right, so this is it. They look at paperwork and then make a decision. All right, let me make sure. Yep, I got everything here. We've got a couple more cases. And moved over here. Now, anytime, some people have asked me before if you've seen id on here, and that just means the citation immediately before what's going on. I don't have the technical legal research and writing term for that, but it's just whatever was just highlighted or whatever was cited before is what they're going to, what they're meaning. So instead of rewriting it again, they just put it in there. All right, there you go. That's your your law school lesson for today. What is id? I don't know. It means the citation before. All right. Oh my gosh. All right, and then now we are into our outline format. And so now we need to start following the color code here. All right, so I just kind of took a minute and put this in order just so we don't forget, because the most important thing when you're annotating is that you do it the same every single time, or as close to the same as you can get every single time. So here we go. Okay, we've got A, we've got 1, we've got little a, and then we've got 1 here, and then we can have a little a here, and then we can get into the little i's. We'll see how that goes. But that's the most important thing. Just do it the same way every time. Yes. Speed reading courses. Yes, I get. Oh, I love it. Adem means the same. Oh, thanks, Chris. Hey, that's nice. Thank you very much for that. All right, so we're in our outline format. So we've got our first letter subsection here, and then we have our first number. It helps. For me, I try to do it in rainbow order, so that just helps me remember what I'm doing. So first thing, I'm going to pull out the code sections. We've got U.S. code sections here, here as well. Here's another code section here. Now, some people would give me a hard time in various offices that I worked in because I went through and annotated everything, right? Not everybody does this, but I will tell you right now, if you have a judge that's like, tell me about 8 U.S. Code Section 1229B here, you're like, boom, well, it's right here, and then you'll know what you're talking about. So for me, I always could answer the judge, like, well, what's your case about? It's like, boom, it's right here. Or do you have a citation for that? Or do you have the code section you're talking about? Everything is highlighted, so you could just pull it right out. It's at your fingertips. So it was just really helpful for me when I was in court. Because when you're in court, you got a lot of things going on. You got a lot of things going on in your head. And so if the judge is like, well, which rule are you referring to? And you're talking about the rules of evidence. If you've got those all broken down by color, it's a lot easier to pull that rule for the judge. Yeah, so it just is a lot easier that way when you're like on your feet and working through a trial. Again, because your brain's not right when you're in the middle of trial. You're not right. And so you got to give yourself whatever you can to help get through it. All right, so next, what I'm noticing now for this, again, this is a U.S. Supreme Court filing, is that they're numbering here outside of their paragraph. So this isn't proper format, which is fine. But now I know I'll need to look for the numbers here if I want to stay in order. The other thing too is that this is where you find the mistakes as well. If you go back, if you can follow the color coding path back, then you can figure out where they may have messed up. And I've done that a few times before too. Like, no, you didn't have the right case, dude. They hate that. They hate that. But the point is to, have a good, clean battle. And you can't have a good, clean battle if someone screwed up their stuff. So I'm like, go fix your stuff and then come back so we can fight. Let's have a good, clean fight here, everybody. Get to your corners. All right, so again, right now, if I'm using blue, it means I'm seeing a code section here, or a rule, or some kind of a citation to law review article or something along those lines, all right? So that's important. So that's what my blues are here. Like, look at this. This is crazy. You have to stand up to, in the court, and you have to say, an alien may be removed to any country willing and able to accept him. And the judge is like, well, which section are you referring to? Well, that's 8 U.S. Code Section 1231 sub B sub 1 sub C sub 4 and 2 sub E sub 7. Like, if you don't have this set out, how are you going to be able to cite that to the judge, right? It's going to be like, I'll get back to you, judge, which is fine. Which is absolutely fine. But, for me, I'm like, I'm in it to win it. Let's get her done. And I don't want to have to come back with all of this extra stuff to tell the judge because I didn't have it with me in the moment. So for me, that was just my personal style, which many people would say is not how they do it. But this is just how I do it here. All right, so again, we're in the Code of Federal Regulation here. So I'm pulling all of these out and I'm putting them in blue. And again, I'm not really reading this because I will go through and read it once the annotations are done because I want to take a look at it, of course. But now if we've got a matter here, a matter of, it's kind of in between. It's not a full case, it's something else. And so that will always go in pink as well. So if it's got some kind of a adversarial role, it will go in pink, even if it's not a full-on so-and-so versus so-and-so here. All right, so just as an FYI, again, there's lots of precedent here. There we go. And then down here, of course, I always jump into these footnotes as well to get the citations. There's a lot of stuff hidden in footnotes, everybody. What's the orange representation? Is it the preliminary injunction? So the orange is, I've got two paths I'm on here. I have the highlighting path for the outline form of the motion here, of the application. And then the other is for the, like the, I don't know, I guess I would call it IRAC. We could call it, right, IRF-RAC, IRF-AC. Oh my gosh. So, and no one's gonna know what that means, but if I'm pulling out rules or if I'm pulling out precedent, I want to know what those mean. So then I've also got colors for that. But the primary colors over here are just the outline. So the orange I'm using right now is just because of the outline format here. All right, so there you go with that. So I've got two categories here. So next, here we've gotten our citations done with the cat and the tea orchard. Let's just look here. This looks interesting for a minute. Let's look and see. So torture is defined as an extreme form of cruel and inhuman treatment, which intentionally inflicts severe pain or suffering on another for an improper purpose and is performed at the instigation of or with the consent or acquiescence of a public official acting in an official capacity or other person acting in an official capacity, according to the Code of Federal Regulation here, and supported by case law here. So this is our precedent, and then they're quoting that case law here. And that pulls us to the second footnote down here. So it says an alien may also seek withholding of removal under the code section, which prohibits the removal of an alien to a country where he would face persecution because of a protected trait. This form of protection is not at issue in this application because the district court limited its injunction to the procedure for raising cat claims. So, and I like to take a minute again, because this is what the government is appealing to the U.S. Supreme Court, right, for the South Sudan case. So here they're saying he's cutting what the judge is saying off here. He's saying the district court's only limit is only talking about raising cat claims, right? Oh my gosh, this just, so this is where he's kind of getting, crappy with picking the words. Can seek withholding of removal, which prohibits the removal of an alien to a country where he would face persecution because of a protected trait. This form of protection. So any of the withholding of removal orders he's claiming are not going to be under this judge's ruling because he's, kind of being yeah. Isn't this what our government's doing to them? Well, right, exactly. And that's why they're filing to the Supreme Court. They're trying to say, no, it's not. It's not against the international treaty. It's not against that. All right, so here we go, back in it. So we've got code sections here, federal code, U.S. code here, FARA, that's a U.S. code statute here. So again, we're just highlighting that, and I've got a lower record reference here, and then further lower record reference. Here we've got the DC docket reference date here, and then continuing on there. So, and then I'm noticing again this 4, because this is, I don't know why they're doing it this way. Maybe this is how they like to do it, but that is just the outline format in here. All right, next. Here we go. We've got section again up here and US code. So all of our code is in blue here again. Up here referencing these sections of, okay, INA here, and then let me just make sure I don't have any more code sections. Now we've got record references again. So the record is what is being seen by the judges here. And I think that's it for the record. The other thing too, though, everyone, is, if you miss something, just you go back and fix it. It's not any big deal. Or if you have the wrong color, it's like you're not going to lose points for that. You just try to, do the best so that you can have it set out in a way that's helpful. So hopefully this gave you some idea. Again, this is a motion here on an application to the Supreme Court. I have several different kinds of filings. So that gives you some idea, kind of halfway in, of how that process works. Now let me grab, I've got one more over here. Where did I put that? Hold on, here we go. No, where'd it go? No. Here we go. Here, just to show you what a finished product would look like. So this is a motion filed, or an application filed. Now this one, which we were working on, now this one is one that I have already annotated. All right. So this is the Harvard College complaint that was filed on the student visa issue. So there's multiple Harvard cases going. This is the student visa. So let me just show you how I've gone through using the same kind of format, but this one I have finished. So each point here I've used a yellow for, but you can see again, I've gone through and pulled out code sections here. Here's my outline format. Whenever I've had a case that they're citing in here, multiple cases, more code sections out of the APA here. But as you go through and you flip through, you can see how broken up this is. So rather than trying to read through all of this text and try to make it through and figure out what's happening and remember it all, I see it as, giving yourself cues so that you've got reference points to go back on. So I haven't done every single thing. It looks like I stopped on blue, but and I'll need to go back through and finish up the blue part. But I did. That's the other thing too, is a lot of times I'll go through the whole thing with just one color. If it's a really complicated case, I'd go through the entire filing and just pull out the code sections, and then go through it again and just pull out the cases, and then go through it again and just make sure my outline format is proper, or just go through and make sure that footnotes are okay. The reason why is just, again, because the way my brain works is just, I have to have the minutia of details in order to recall what it is. And then by the time I'm done briefing it and annotating it, this is it. I will remember this case for, a while. I'm not going to remember your name, but I will remember the Harvard petition. That's just a way that helps me. Right. Exactly. And you can set your own code too, your own color coding process that you want to use. That is up to you as well. And again, it's, I was never very good at, just the rote memorization stuff. For me, I really needed the full story. I needed the story in order to remember what was really going on. And sometimes you just don't have the story, so you got to make your own story here. So, all right, so here's another one. Let me see here. Oh, here it is. This is what I wanted to show you. So this is a case. This is another application for a stay that was sent up recently to the U.S. Supreme Court. Ooh, puzzle piece, everybody. Wish me luck. Here we go. Did we get it? No, we missed it. Hold on, everybody. Let's try again. All right, here we go. Get the puzzle. Okay, we got it. Yay! Success. We love it. All right. So here's the next one. Here. So Supreme Court, if you're in, this is, when we call this briefing a case here, and you can do book briefing, or you can do regular case briefing where people write it out. Oh my gosh, everyone. See, this is just the quick way I do things. Back when I was in law school, oh my gosh, I had all the cases on index cards. I was crazy. I was absolutely bonkers. And I had, depending on how complicated they were, I had giant index cards, and I would handwrite out the cases, and then I put them in a recipe box, and then I would just flip through and pull whatever cases out I needed. And so when I studied for finals, I had this big box of cases, and I would just pull out the major cases that I needed for my outline, and then I would put them on medium-sized cards. All right, so something like normal size. And I would just make another batch, and then I would, flip through those. And then depending on how much time I had left, I would put them on little mini index cards. And I had a different set of boxes for all of the cards. And so I could just, look at them as I was walking around and color code them and things like that in order to remember. And again, it's just what worked for my brain. Yes, it just what worked. Yeah, it could have been sticky notes. It's just what worked for me to remember how things were going forward. And I think too, when you have I've got ADHD, and I'm, that's one of my superpowers. And so for me, it was so difficult to not see all the squirrels. And so I needed to have a format that I could, almost play with when I was doing what I was doing, so that it was interesting enough for me that I could get the information in. And so that's kind of what I did. Hello, Sarah. Welcome. Had no life. Well, that was my life. My life was law school. and that was okay. Oh, yeah, the amino acids. Oh, sure. And all the bones in the body. Absolutely, absolutely. All right, so let's take a look. This will be just a real quick showing of how I go through and brief a case. This is just the summary of the case. Actually, this is the decision of the case. This particular case is just ridiculous here. But I'm looking through again. I'm using pink. I'm looking for any cases that they are citing first. So I'll pull those out here. So precedents in pink. Trump versus International Refugee Assistance Project, right here. And then, do we have any other cases here? No. So then next, I'm going to go back and look and see what code sections they're using. We've got 29 U.S. code here, 5 U.S. code here, and Constitution. Anytime the Constitution is cited, I try to pull that specifically out. So Article 2, the executive branch, Section 1, Clause 1 is what we're citing here. And then that's it for that. Flipping over, we have, all right, so this is the record below, right? So it's just going to be in yellow. The lower record, they are responding to, we disagree, Yeah, I'm surprised, Supreme Court, you're disagreeing. And then in here again, oh, we have another case. So here, now let's see, March 4th, the order of the United States District Court for the District of Columbia. And then here's the citation for that, ECF Doc 39. So this again is a reference to a prior case in a lower record. So I would just put that into yellow here. So there you go. That just gives you some idea, of how a quick case briefing would go. Yes, Heather. Exactly. Yes. So P for pink parties and precedent is usually how I've done it. And so then we have a dissent over here, and I would go through and look through that if I had time. So again, this is just another kind of document when going through and annotating whatever it is that I need to do. So again, I've just got a ton of different kinds of documents here, everyone. Here is a book I put together. So these are the rules of the U.S. District Court for the District of Columbia. Because so many cases against the administration are filed in D.C., this is huge. So I wanted to make sure I had the local rules, because every different court has its own local rules that they use. So these are the federal rules for D.C., and I've not annotated this at all. I need to go through and pull these all out, but I haven't yet. So I'm looking at it and I'm like, oh my gosh, I've got a lot of work here to do. But again, you have to just remember your outline format and just use the same format every single time. But what's so interesting, what people, may not realize is like every single thing in the legal field has a rule. Right? So you're like, oh, well, I don't know how to do continuance. It's right here. You go and look at the continuances. Well, what kind of notice do I have to do for a continuance? Well, read the rule. It's right there. Or if you have a duty to confer, what exactly that looks like. Pretrial statements, what are we going to do in there? Like there's a rule for every single thing. Is it a class action, right? So we're dealing with a lot of class actions. How does that work? So, for example, let's take a look at class action here on page 45. Here, yeah, we go. Page 45. Okay, here we go, class actions. So, and there we go. We've got the rules right there in front of us. Class action allegations. Down here, reference or portion of part of the federal rule of procedure here. So Federal Rule of Civil Procedure, right? All right, everybody, my full dork is on right now. Okay. All right. So then you can pull out your Rule of Civil Procedure, and then that can help you go through that as well. Tons of people have no idea how to follow directions. I know, right? And that's the thing about the legal field is that if you just can figure out what the keys are, you can go anywhere you want to go. Like you can see how these executive orders are just way out of line and so far unconstitutional. And you can see how the filings are huge violations of ethics because you just know the rules. All you got to do is just know the rules or where to find the rules. And then you'll be okay. So this particular set here, hold on a second. So let me get this. This is not the best binding that I have, but this is just what I had at the time. So these are the rules again for the District of Columbia. So this is how they like to have their stuff done. So if you're in the U.S. District Court for Massachusetts, they have their own book. Or for California, they have their own book. Northern, Southern, they have their own book. So every single district will have its own book of rules, of local rules. I had gone through the Florida rules for the Florida classified documents case and had looked through those and spent some time on that. But the DC rules again here, and you can see I've annotated on the side. This is like a micro annotation over here for the rules, but it's just really helpful. It makes it easier to find what you're looking for. Yes, a grown up. This is why attorneys get paid. Well, I tell you, there are some of us that are like this, and some of us that are not. So, and again, here's the rules of civil procedure. But, I think the best description, and I've always used this as an example, if you've seen the movie A Few Good Men, which was like decades ago, when we have like Tom Cruise is in there like playing baseball and cutting deals. Meanwhile, Demi Moore's like, I did 3 cases in 5 years because she had every single scrap of paper filed. So I'm more on the Demi Moore side. But if I had to, and many times I did, I would run into the court and do the Tom Cruise work if I needed to. But yeah, and I think again, the whole point is, when you're in another field, if you're a nurse, right? You go in and you're a nurse, you've learned different things and you've got the knowledge because you've gone in and worked on the people, right? You do your lab and you do your stuff and you work on the people. But, for us, our tool is just our brain. And the only way to really, do the work or do the situation to load the law up is to read the rules. So that's kind of how we do it. A new order came down about emergency powers and tariffs. I was wondering, I was waiting on, is it the California one? Is it, because the California tariffs case was waiting on an order. So I may need to take a look at that. Okay, there are courses Harvard's offering. Okay. Parnas is saying the judge ruled the tariffs are invalid? What? Seriously? In New York? Really? Oh my gosh. Do you know the name of the case? Okay. Okay, hold on, everybody. That's pretty big news. Just a minute. I tell you what, that Aaron guy just keeps me busy. Here we go. Let me just check it out. So this is the New York tariffs. This is not the California. Okay. Right, and to vacate. Okay. Let me, hot off the press. Yeah, let me pull it up. Here we go. Oh my goodness. Yeah, well, there were 2 tariff cases that we were waiting for orders on. So let me see here if I can find it. Oh my gosh. Here we go. A U.S. court blocks Trump's Liberation Day tariffs. All right. Oh my goodness. What? Which case is it? The Liberty Justice Center lawsuit. Oh, what? Okay. Let me see here, everyone, if I can pull this up and print it real quick. Okay. All right. So this is the Oregon. Let me see if I can find the order here. Here we go. Federal court. Liberation Day. Here we go. Overreach of authority. Yeah, shocker. Okay, here we go. Where is it? Hold on, everyone. Here, I'm trying to pull the. I hope is it published? Is it up yet? Sorry, everybody. I'm over here talking to myself. No rush. Okay. Oh, thanks. Appreciate that. All right, here we go. Let me pull the case. All right, led by Oregon. All right, so Oregon lawsuit here. All right. Here we go. One more. Okay. Just 1 second, everybody. I'm still here. I'm sorry. Oregon. All right, Oregon v. Trump. It's the IEEPA tariffs case. And let's see if they've got the order published. Let's take a look. Well, the IEEPA, that was a huge issue. That was a huge problem, you know, with the idea that there's some kind of an emergency going on in order to make these kinds of tariffs, right? Okay, so we've got the U.S. Court of International Trade. It's loading, everyone. I've not seen the order yet. It's still loading. Made up emergency. True. Right. Yes, hot off the press. It's still loading. I pulled the case up here, but it's still loading. So let's see. All right. Oh my gosh. Yeah, 1977. Oh, here it is. All right. Here we go. I'm so excited. Oh my gosh, I'm so excited. Ooh, okay. I'm such a dork. All right, here we go. Let me print it out, everybody, and then I can bring it over. This is just great. We love this for us. This is great news for us because things are crazy. All right, we've got transcript, oral argument, main document. We've got, okay, so look at this. It's another win for our poster, everybody. We've got motion for summary judgment granted. All right, that one's getting printed. Hold on here. What else is getting? All right, hold on. I got to reload the paper. Just a second. Okay, so it's almost 50 pages, so that's going to take a minute to print. Here we go. This is what we're talking about here. United States Court of International Trade. It got moved over there. So we have VOS, and these were combined together here. State of Oregon. All right, here's the judgment as they go through. The analysis is coming. Oh my gosh, Aaron's amazing. Oh my gosh, I know. If anyone needs a fruit basket these days, it's Aaron. Oh my gosh. All right, here we go. In accordance with the court's opinion of this date, which is printing right now, it's hereby ordered that Executive Order 14193, imposing duties to address the flow of illicit DRUGSs across our northern border. Whoa, Executive Order 14194, imposing duties to address the situation at our southern border. Oh my gosh, look at all these executive orders that they're knocking out. This is huge. Here we go. 1494. Okay, 14195. It's the next one. 14257. Wow. Whoa, that's fantastic. Tea break, thanks. I'm just so excited. I just forgot. All right, so I see 4 executive orders that have been knocked out by the court. That's huge. I don't think I've ever seen this many executive orders knocked out by one case in one court. That's huge. All right, so collectively they're called the challenged tariff orders here. So we've got all of these and all modifications and amendments thereto be and hereby are declared to be invalid as contrary to law It's further ordered that the operation of the challenged tariff orders and all modifications and amendments thereto be and hereby is permanently enjoined. Oh my goodness, everybody, this is wow. It is further ordered that within 10 calendar days necessary administrative orders to effectuate the permanent injunction shall issue, and it's further ordered that each party shall bear its own costs by the panel. Whoa, that's huge. That's huge. I can only imagine. Yeah, I know. All right, so I think it just finished printing. Let me go grab it. Okay, everybody. Whoo, it's hot. It's hot. It's hot off the presses. Here we go. Ooh, hot. There we go. Let's move some of this out of the way. Yes, my ring's changing color. My ring's very excited. All right, let's take a peek, everyone, and see what has just happened. Yeah, so, okay, 4 executive orders. So here we go. Opinion. So the court grants plaintiff's motion for summary judgment and denies plaintiff's motion for a preliminary injunction as moot. So we don't need an injunction if we have denied this. Yeah, her face was pretty close actually to the printer. I was a little worried. All right, let's clear some room here, everyone. If you could actually see, I'm literally swimming in documents right now. Here we go. All right. So all of these people. Okay, per curiam, which means from the bench. We don't know who wrote the decision. The Constitution assigns Congress the exclusive powers to lay and collect taxes, duties, imposts, and excises, and to regulate commerce with foreign nations. The question in the 2 cases before the court is whether the International Emergency Economic Powers Act of 1977, or IEPA, delegates these powers to the president in the form of authority to impose unlimited tariffs on goods from nearly every country in the world. The court does not read IEPA to confer such unbounded authority and sets aside the challenged tariffs imposed thereunder. Oh my gosh, that's so exciting. So exciting. All right, well, let's take a cruise through this, everybody, if you're all right with that. Let me make a little note here so we know what case we're talking about. Oh, yes, one of the states. Yeah, there's quite a few. I think there were like 12 states involved here. So let me see. How do we want to put this case? It's Oregon, Arizona, Colorado, Connecticut, Delaware, Illinois, Maine, Minnesota, Nevada, New Mexico, New York, and Vermont. All right. We love that. Okay, here we go. We're going to call this Oregon. That's what the title is on court listeners. So Oregon here. V. What do we have? DHS, I guess. DHS. Tariffs. Is it 2 R's? Oh my gosh, everybody. Is it 2 R's and 1 F? I think it's 1 R and 2 F's. Tariffs case. Executive order here. Executive orders held unconstitutional. All right, here we go. I know. 1 R, 2 F's. Thank you, Moon Sister. I appreciate that. Thank you so much, Krista. See, now that you've seen my annotations, now you know why my brain doesn't have regular words in it. All right, here we go. Let's take a peek. We'll just kind of skip and go through the first bit here. So here's our background, the Constitution. While Congress may not transfer to another branch powers which are strictly and exclusively legislative, Congress may confer substantial discretion to implement and enforce the laws. Right, the president cannot make law, so his executive orders cannot make law. Thus, courts have consistently upheld statutory delegations as long as Congress lays down by legislative act an intelligible principle to which the person or body authorized to exercise that authority is directed to conform. This reflects the idea that in modern government, the legislative process would frequently bog down if Congress were constitutionally required to appraise beforehand the myriad of situations to which it wishes a particular policy to be applied and to formulate specific rules for each situation. Okay, so B, tariffs. Early in the nation's history, tariffs were a key means by which the federal government raised money to pay wages and to fund the national debt. All right, the revenue-raising purpose of tariffs has declined significantly since the ratification of the 16th Amendment in 1913. So 16th Amendment is income tax, everyone, just so you know. Permitted the imposition, well, there it is. I suppose I could have just kept reading. Sorry. In 1913, permitted the imposition of income tax. Since then, and with the increasing complexity and interconnectedness of the global economic landscape, tariffs have served more diverse purposes, including restricting the importation of certain goods, protecting American industry, and leveraging negotiations with foreign counterparts. All right. As global economic relations grew in volume and complexity, Congress saw a need for specialized nonpartisan assistance in administering tariffs. Congress accordingly passed legislation creating the United States Tariff Commission, later renamed the United States International Trade Commission. Right. There we are here. The Revenue Act is where the citation's coming out of for the ITC. To provide this assistance, the Commission shall have the power to investigate the tariff relations between the United States and foreign countries, commercial treaties, the volume of importations compared with domestic production and consumption, and conditions, causes, and effects relating to competition of foreign industries with those of the United States. The ITC is responsible for maintaining the United States harmonized tariff schedule. I didn't know we had one of those, which sets tariff rates for all merchandise imported into the United States. The HTSUS, is it HTSUS? I don't know. Itself is indeed a statute, but is not published physically in the United States Code. That's weird. If it's all right, well, whatever. Congress's enactment of HTSUS provided that its terms shall be considered to be statutory provisions of law for all purposes. Right. So, in addition to forming the ITC, Congress has responded to the growing complexity of global economic relations by delegating trade authority to the president. Okay. These delegations have included clear limitations that retain legislative power over the imposition of duties and over, it's just in somebody's head, I hope not, kind of like the UK's constitution, like whose head is it in? Foreign commerce here. And then citing case law here. What's done by the Tariff Commission and the President in changing the tariff rates to conform to new conditions is in substance a delegation, though a permissible one, of the legislative process. For example, in 1962, Congress delegated to the President the power to take action to adjust imports when the Secretary of Commerce finds that an article is being imported to the United States in such quantities or under such circumstances as to threaten to impair the national security. Okay, this delegation is conditioned upon the investigation and findings by the Secretary of Commerce and agreement by the President. Okay, Section 301 of the Trade Act 1974, as amended, requires the U.S. Trade Representative take action which may include imposing tariffs where the rights of the United States under any trade agreement are being denied, or an act, policy, or practice of a foreign country is unjustifiable and burdens or restricts United States commerce. The USTR may impose duties also where the USTR determines that an act, policy, or practice of a foreign country is unreasonable or discriminatory and burdens or restricts United States commerce. This power is conditioned on extensive procedural requirements, including an investigation that culminates in an affirmative finding that another country imposed unfair trade barriers under Section 2411A1A or B, and a public notice and comment period. Oh, I love this. So the judge is taking everybody through like how it's supposed to actually work. All right, so that was the tariffs piece. Now we've got the presidential authority to regulate importation during national emergencies. In 1917, Congress passed the Trading with the Enemies Act. Why do we have so many enemy acts? All right, here we go. To grant the president powers to regulate international transactions with enemy powers following the entry of the United States into World War I. Right. The Great Depression then led Congress to expand the president's authority under a TWEA to declare states of emergency and exercise authority over international trade, even outside times of war. TWEA, as amended, grants the president the broad authority to regulate importation or exportation of any property in which any foreign country or national thereof has any interest. In 1974, the U.S. Customs Court, the predecessor of the U.S. Court of International Trade, heard a challenge to President Nixon's imposition of a supplemental duty on all dutiable merchandise imported to the United States. Nixon's involved again, of course. The government argued that Nixon's actions were lawfully authorized by TWEA. The U.S. Customs Court construed TWEA so as to preserve its constitutionality and held that TWEA precludes the president from laying the supplemental duties provided by President Nixon. The United States Court of Customs and Patent Appeals, the predecessor of the United States Court of Appeals for the Federal Circuit, reversed the lower court's decision, holding that President Nixon's duties were within the power constitutionally delegated to him. The court reasoned that Congress, in enacting TWEA, authorized the president during an emergency to exercise the delegated substantive power, regulate importation by imposing an import duty, surcharge, or by other means appropriately and reasonably related to the particular nature of the emergency declared. Shortly after this decision and following a review by a Senate bipartisan special committee, Congress reformed the president's emergency power. As part of this reform, Congress combined the president's powers under TWEA to wartime. All right. Congress also enacted a new statute, IEPA, to confer upon the president a new set of authorities for use in time of national emergency, which are both more limited in scope than those of TWEA and subject to more procedural limitations, including those of the National Emergencies Act, right, which was codified here. Congress drew much of the relevant language in IEPA from TWEA, including language authorizing the president to regulate importation of any property in which any foreign country or a national thereof has any interest by any person subject to jurisdiction of the United States. In full, the relevant provision here. All right, so this is a relevant provision. I'm going to skip this, everyone. I know it's important, but I'm trying to just hit the highlights here. So here's the relevant piece. IEPA further provides that these authorities may only be exercised to deal with an unusual and extraordinary threat with respect to national emergency, which has been declared for purposes of this chapter, may not be exercised for any other purpose. Here, the National Emergencies Act, as part of Congress's reform to the president's emergency powers, and in addition to amending TWEA and enacting IEPA, Congress enacted the National Emergencies Act here. That act provided for the termination of all existing emergencies in 1978, except those making use of TWEA, and placed a new restriction on the declaration of emergencies. This is so important, everyone. I mean, we've got like 6 national emergencies being declared right now. For everything from like importing timber to all these tariff issues. So this is huge for the judge to come in and be like, your national emergency is not appropriate. That we've got 4 executive orders here, but it's going to knock out a whole bunch more when other courts start saying, well, now we've got a ruling on it. First, the NEA requires the president to transmit to Congress a notification of the declaration of a national emergency. Second, the act requires a biannual review whereby each House of Congress shall meet to consider a vote on a resolution to determine whether the emergency shall be terminated. At the time of its enactment in 1976, the NEA afforded Congress the means to terminate a national emergency by adopting a concurrent resolution in each chamber. However, the Supreme Court later found Congress's use of unicameral legislative vetoes, which terminated executive determinations without presentment to, be unconstitutional. All right, whatever. Supreme Court, Congress subsequently amended the NEA to require a joint resolution rather than a concurrent resolution. That's a good call. So they're saying unicameral just means only one of the houses is allowed to do that. Hold on, everybody. I just went through one of my batteries. Hold on. Oh my gosh. Next battery. Here we go. Oh my gosh. This is so exciting, everybody. Woohoo! This is really exciting. I'm just like giddy. I'm so excited about this order. Oh my gosh. All right, here we go. Where were we? Next battery pack. We're locked and loaded. Here we go. Following this case, congressional action terminating a national emergency is still subject to presidential veto, making congressional review no more than the ordinary power to legislate. All right, done. Since taking office on January 20th, the president's declared several national emergencies and imposed various tariffs in response. The president has subsequently issued a number of pauses and modifications to those tariffs as outlined in the detail below. Is this a taco thing that I'm hearing about, everybody? Is this what we're talking about, the modifications and pauses? Is that where the taco's coming from? I'm just curious. I'm just asking the chat here. Is that, just wanted to make sure. Yes. Okay. Yes. Oh, I love it. I love it. All right. Here's trafficking tariffs. On the date of his inauguration, the president issued an executive order 1415-7 declaring a national emergency under IEEPA to deal with the threats posed by the international cartels that have engaged in campaign of violence and terror throughout the Western Hemisphere that has not only destabilized countries with significant importance for our national interest, but also flooded the United States with deadly DRUGSs, violent criminals, and vicious GANGSs. Executive Order 14157 here. The president issued Proclamation 1088-6 on the same day, declaring a national emergency at the southern border caused by cartels, criminal GANGSs, known terrorists, human traffickers, smugglers, unvetted military-age males, what? From foreign adversaries and illicit narcotics that harm Americans. Oh my gosh, I don't think I read that. I haven't read that particular executive order. Shortly thereafter, the president expanded the national emergency to cover the threat to the safety and security of Americans, including the public health crisis of unalives due to the use of fentanyl and other illicit DRUGSs, and the failure of Canada, poor Canada, oh Canada, sorry, to do more to arrest, seize, detain, and otherwise intercept DRUG trafficking organizations, other DRUG and human ickers, criminals at large, and DRUGSs. Fast forwarding. Similarly, the president expanded the national emergency to cover the failure of the People's Republic of China government to arrest, seize, detain, or otherwise intercept chemical precursor suppliers. Really? Money launderers, other transnational criminal organizations, criminals at large, and DRUGSs. All right, here's that executive order here, 1419-5. In response to these emergencies, the president imposed 25% ad valorem duties on articles that are products of Canada and Mexico. Here's our executive order, 1419-3. Here, and 10% ad valorem duty on articles that are products of China. Executive Order 1419-5. The president imposed a lower 10% ad valorem rate on energy and energy resources from Canada. That's, I think, the timber one that I was thinking of here. So that's 1419-3. These duties were to take effect on February 4th of 2025. The president later raised the trafficking tariffs on Chinese products from 10% to 20% under 1422-8 here. And on February 3rd, shortly after imposing the trafficking tariffs, the president issued 2 additional executive orders, finding that the governments of Mexico and Canada have taken immediate steps designed to alleviate the illegal migration of illicit DRUG crisis through cooperative actions. And that is Executive Order 1419-8. Here, Executive Order 1419-7, just those 2, it looks like. As a result, the president imposed a pause on the 25% duties on Mexican and Canadian products and on the 10% duties on Canadian energy and energy sources, moving the effective date of those duties to March 4th. Here, can you slide the document down a little bit? Absolutely. Absolutely, everybody. I rely on the chat to tell me if I'm in frame or not here. All right, since the trafficking tariffs took effect on February 4th for China and March 4th for Canada and Mexico, the president's modified the rates further. The president lowered the duty rate for potash. All right, potash, everybody. Footnote 1, potash is a soluble source of potassium and is primarily used as an agricultural fertilizer. What? Not the potash. From Canada and Mexico to 10%. That's huge for farmers. Come on, man, the farmers. 1423-1 and Executive Order 1423-2. Man, our farmers are just getting it. Here we go. And then, additionally, the president implemented a duty-free de minimis treatment for otherwise eligible covered articles. Executive Order 1422-6. Here, Executive Order 1422-7, Executive Order 14-200. My goodness, look at all these executive orders, everybody. This is just really a lot. The president later removed this duty-free de minimis treatment for Chinese products, according to Executive Order 14-256. Here, currently the tariffs, I'm not going to say this other T word, I'm worried now. Currently, the tariffs all remain in place at a 25% for Mexican and Canadian products and at a 20% for Chinese products. The tariffs on Canadian energy and energy resources remain at the lower 10% rate. All of these tariffs, including the modifications listed here, are hereafter referred to as the trafficking tariffs. I guess we won't be able to get around that word. Worldwide and retaliatory tariffs. Oh my gosh, are we ready? I'm not sure if I'm ready for that. On April 2nd, the president issued Executive Order 1425-7 invoking IEEPA to impose a general 10% ad valorem duty on all imports from all trading partners, which shall increase a list of 57 countries to higher rates ranging from 11% to as high as 50% ad valorem. And that's Executive Order 1425-7. Here, the president imposed these tariffs in response to a national emergency with respect to underlying conditions, including a lack of reciprocity in our bilateral trade relationships. Is that lack of reciprocity? Is that also like quid pro quo? Is that kind of the same thing? I'm wondering. I'm just curious. It seems like they're in the same world. Desperate tariff rates and non-tariff barriers in the U.S. Trading partners, economic policies that suppress domestic wages and consumptions, as indicated by large and persistent annual U.S. good trades deficits. The president stated that these large and persistent annual U.S. good trade deficits constitute an unusual and extraordinary threat to national security and the economy of the United States, having its source in whole or substantial part outside of the United States, in the domestic economic policies of key trading partners, and structural imbalances in the global trading system. On April 9th, the president issued another executive order that paused for all countries but China the implementation of the higher country-specific tariffs for 90 days, moving their effective date to July 9th. Again, that's crazy town. We're in crazy town. Okay, Executive Order 1426-6. As China responded to the various country-specific tariff adjustments by adjusting its own tariff rates on U.S. goods, the president has amended the duty rate on Chinese goods several times in retaliation. The president first increased the China-specific duty rate from 34% to 84%, effective April 8th, under Executive Order 1425-9. here. And then from 84 to 125% on April 10th, Executive Order 1426.6. Currently, the worldwide tariff remain in place at 10% for all countries, while the country-specific higher rates are set to take effect on July 9th of 2025. Can anybody keep up with all these changes? I mean, with all of the tariff switches, like, this is ridiculous. The China specific rate is now also at 10%. Footnote 2, this 10% rate is in addition to the 20% trafficking tariff addressed above. The total rate for Chinese goods is thus currently set at 30%, subject to various exemptions not discussed here. Oh my goodness. All right. After President Trump lowered the 125% retaliatory tariffs in response to China taking a significant step towards remedying non-reciprocal trade arrangements and addressing the concerns of the United States related to economic and national security matters. Executive Order 1429.8 here. This lower rate is effective until August 12th. All of these tariffs, including the modifications listed here and hereafter, will be referred to as the worldwide and retaliatory tariffs. Wow, that's not a good title. That's all right. So procedural background here. I will skip through this procedural background, everyone. They're saying lawsuits. All right. there were lawsuits involved here. Jurisdiction here. So this case is being decided in the Court of International Trade. All right, so the U.S. Court of International Trade, it's a slip opinion as of right now. So that jurisdiction has been established. So I'm not going to spend a lot of time on this either here. Jurisdiction, standing, and that means if you have an injury that has a close enough nexus with the person who did the injury in order for you to bring a lawsuit. All right. So Article 3 standing is important. That analysis is in there. And we'll probably hear about a jurisdiction and standing later on down the road. Those are huge legal arguments. But I'm fast forwarding here because I want to get to the emergency piece of it here. Standing for the plaintiffs. They've got standard of review here. And there is a standard of review. Do we get refunds? All right, so here's our discussion. Here we go, everyone. Now we're going to get into the meat part of it, or tofu, whatever, protein of choice. Discussion. Underlying the issues in this case is the notion that the powers properly belonging to one of the departments ought not to be directly and completely administered by either of the other departments. And this is Federalist number 48, James Madison. Here we go. Let's get James Madison out. Here he is. Hey, James Madison. All right. If you quote James Madison, I'm going to bring out James Madison. All right. That's just how that's going to go. Because of the Constitution's express allocation of the tariff power to Congress, we do not read IEEPA to delegate an unbounded tariff authority to the president. We instead read IEEPA's provisions to impose meaningful limits on any such authority it confers. Two are relevant here. First, Section 1702's delegation of a power to regulate importation, read in light of its legislative history and Congress's enactment of more narrow non-emergency legislation, at the very least does not authorize the president to impose unbounded tariffs. The worldwide and retaliatory tariffs lack any identifiable limits and thus fall outside the scope of Section 1702. Second, IEEPA's limited authorities may be exercised only to, quote, deal with an unusual and extraordinary threat with respect to which a national emergency has been declared and may not be exercised for any other purpose, end quote. Here. As the trafficking tariffs do not meet the condition, they fall outside of the scope of Section 1701. So, again, the court's going through and trying to explain this here, that we don't have an emergency. And that's such a huge piece. That's such a huge piece because all of these emergencies have been what he has been using for so many orders, not just the tariffs. All right, 50 U.S. Code Section 1702 does not authorize the worldwide and retaliatory tariffs, and let's see why here. Plaintiffs in both cases argue the words regulate importation do not confer the power to impose tariffs. Any other interpretation, according to plaintiffs, would run afoul of both the non-delegation doctrine and the major questions doctrine. So that's a bit of a highbrow discussion. The government counters that the words regulate importation have the same meaning that they did in TWIA, an older statute that was found to delegate a power to impose tariffs. Plaintiffs are correct in the narrow sense that the imprecise term regulate importation under any construction that would comport with the separation of powers underpinnings of the non-delegation and major questions doctrine does not authorize anything as unbounded as the worldwide and retaliatory tariffs. Did everybody get that? I'll go through and explain it here in a minute. When statutory language is susceptible of multiple interpretations, a court may shun an interpretation that raises serious constitutional doubts and instead adopt an alternative that avoids those problems. The court in Yoshiba 2, this was the Nixon situation, I believe, recognized that a case involving a claim to such unlimited authority might arise, observing that, quote, whether a delegation of such breadth as to have authorized the tariffs here would be constitutionally embraced is determined by the nature of the particular surcharge herein and its relationship to the other statutes, as well as by its relationship to the particular emergency confronted here. That case has arisen here. An unlimited delegation of tariff authority would be unconstitutional. The Constitution provides that all legislative powers herein granted shall be vested in a Congress of the United States. Congress is empowered to make all the laws which shall be necessary and proper for carrying into execution its general powers. The Constitution thus establishes a separation of powers between the legislative and executive branches that the framers viewed as essential to the preservation of individual liberty. The Federalist number 48, again. Madison, where'd you go? Here he is. Hi. To maintain the separation of powers, the Congress manifestly is not permitted to abdicate or transfer to others the essential legislative functions with which it thus vested. And we're citing an 1892 case here. Dang, the parties cite two doctrines, the non-delegation doctrine and the major question doctrine here, that the judiciary has developed to ensure that the branches do not impermissibly abdicate their respective constitutionally vested powers. Under the non-delegation doctrine, Congress must, quote, lay down by legislative act an intelligible principle to which the person or body authorized to fix such tariff rates is directed to conform. A statute lays down an intelligible principle when it meaningfully constrains the president's authority. Under the major questions doctrine, when Congress delegates power of vast economic and political significance, it must speak clearly. The doctrine applies in extraordinary cases in which the history and the breadth of the authority that the executive branch has asserted and the economic and political significance of that assertion provide a reason to hesitate before concluding that Congress meant to confer such authority. All right. Plaintiffs in some amici argue the government's interpretation transforms IEPA into an impermissible delegation of power because the president's assertion of authority here has no meaningful limiting standards, essentially enabling him to impose any tariff rate he wants. Yikes! On any country at any time for virtually any reason. Similarly, plaintiffs suggest that Congress's use of the words regulate importation does not indicate the clear mandate necessary to delegate such unbounded authority to the president to make such decisions of vast economic and political significance as the wide-scale imposition of tariffs. So they're saying, again, here, it's just too far. It's too much power he has assumed in doing this. The government counters that IEPA contains sufficient limitations. The president must declare a national emergency. The emergency expires after 1 year unless renewed. The emergency must be declared with respect to unusual and extraordinary threat, and the powers must extend only to property in which a foreign country or foreign national has an interest. I think it's really worth noting for the VOS case that we're not just talking about, okay, was Congress clear when they wrote the language, but it can only be seen as appropriate and a proper piece of legislation if proper if proper, oh, I'm sorry, everybody. Hold on a second, my brain. Restrictions are put on the president. So without any restrictions, it would be, per se, not constitutional. So that's why the government's saying, well, there are some restrictions put into place, and they rise to the level of being enough for this to be allowable, for this behavior to be okay. The separation of powers is always relevant to delegations of power between the branches. Both the non-delegation and the major questions doctrine, even if not directly applied, to strike down a statute as unconstitutional, provide useful tools for the court to interpret statutes so as to avoid constitutional problems. These tools indicate that an unlimited delegation of tariff authority would constitute an improper abdication of legislative power to another branch of government. Ooh, there it is. There it is, everybody, right here. So they're saying, based off of the rules that we have to use, this is not appropriate. This is not okay. Regardless of whether the court views the president's actions through the non-delegation doctrine, through the major questions doctrine, or simply with separation of powers in mind, any interpretation of IEPA that delegates unlimited tariff authority is unconstitutional. All right. Let's kind of skip through this piece a little bit as well. We've got the words regulate and importation do not authorize the president to impose unlimited tariffs. And so that analysis is in here. Again, I'm just hitting the highlights. This is still warm. Congress delegated narrower authority to the president through IEPA than it delegated through TWIA. So the court's sitting out, he has even less than what Nixon had, and Nixon wasn't allowed, so he certainly cannot be. Next, Congress combined the president's authority to impose tariffs in response to a balance of payments deficits to non-emergency legislation. That's another major hit as well. And we're kind of fast forwarding here through this. Number 2, 50 U.S. Code Section 1701 does not authorize the trafficking tariffs. All right, so I just read the retaliatory tariffs. So here's the court's response to the trafficking tariffs here. So IEPA does not authorize the trafficking tariffs for the separate reason that they do not satisfy the conditions that Congress imposed in 50 U.S. Code Section 1701. And which is here, and bumping down, this provision limits the president's exercise of IEPA powers to a limited set of situations. All right, so we're citing case law identifying a statutory condition necessary for the president to take action. Under IEPA, powers are available only where all of the following conditions pertain. So not just one, but all of them. First, there must be a threat which has its source in whole or substantial part outside of the United States to the national security, foreign policy, or economy of the United States. Do we have that? Second, this threat must be unusual and extraordinary. Is it unusual? Immigration? I'm not sure. 3, a national emergency must be declared with respect to the threat. All right. And 4th, the president's exercise of IEPA authority must deal with the threat. All right, so all 4, and let's see. Both sets of plaintiffs assert that the orders implementing the worldwide and retaliatory tariffs do not meet the unusual and extraordinary condition imposed by this section. State plaintiffs argue that the orders implementing the trafficking tariffs do not meet the deal with condition. By the government's telling, the court cannot ever question the president's assertion that his IEPA authority deals with an unusual and extraordinary threat. Ooh, that's worrisome. Let's put a little red flag here. That's concerning. All right, so it's outside of the bounds of judicial review, which that's troubling. The government invokes the political question doctrine, under which a controversy is non-justiciable, where there is a textually demonstrable constitutional commitment of the issue to a coordinate political department or a lack of judicially discoverable and manageable standards for resolving it. Nixon v. U.S., and this is the 93 case. All right, everybody. So it's not the tapes case. All right. Quoting Baker v. Carr, the court concludes, however, that the question of the scope of Section 1701 is one, a justiciable question of statutory construction, and two, resolves in favor of the plaintiff's contention that the trafficking tariff orders do not deal with an unusual and extraordinary threat. Those orders thus lie outside the bounds of Congress's delegation of authority to the executive branch. Again, so, what they're saying here is that it's too far. So sub A, political question doctrine does not preclude judicial review of trafficking orders here. And we're skipping here. We're fast-forwarding still. And B, the trafficking orders fall outside of 50 U.S. Code Section 1701's delegation of authority. Right. And skipping, and I think that was really one of the biggest arguing pieces, was they were saying, well, Congress said that the president could do this, blah, blah, blah. And, the court's like, no. So let's let me back up here because we're almost to the end. So let me back up the final piece. So Yoshida 2, go back to Yoshida. All right. Here we go. We'll back it up and come in then to the conclusion. The government's pressure argument effectively concedes that the direct effect of the country-specific tariffs is simply to burden the countries they target. It is the prospect of mitigating this burden, the government explains, that will induce the target countries to crack down on trafficking within their jurisdictions. But however sound this might be as diplomatic strategy, it does not comfortably meet the statutory definition of dealing with the cited emergency. Ooh, we love that. That's great. It is hard to conceive of any IEEPA power that could not be justified on the same ground of pressure. The government reading would cause the meaning of deal with an unusual and extraordinary threat to permit any infliction of a burden on a counterparty to exact concessions regardless of the relationship between the burden inflicted and the concessions exacted. If deal with can mean impose a burden until somebody else deals with it, then everything's permitted. It's a little cheeky there. That's kind of funny. It means the president may use IEEPA to take whatever actions he chooses simply by declaring them pressure or leverage tactics. That will elicit a third party's response to an unconnected threat. Surely this is not what Congress meant when it clarified the IEEPA powers may not be exercised for any other purpose than to deal with a threat. The court in Yoshida 2 explained that, quote, whether a delegation of such breadth as to have authorized Proclamation 4074 would be constitutionally embraced was a function of the surcharge's relationship to the particular emergency confronted. The court further explained that a standard inherently applicable to the exercise of delegated emergency powers is the extent to which the action taken bears a reasonable relation to the emergency giving rise to the action, and that the nature of the emergency restricts the how of its doing, the means of execution. Oh my goodness, the means of execution, everybody. All right, here we go. We're coming down to the finish line here. The government's concept of leverage would sap these words of their meaning. The president's chosen means of execution here are tariffs on articles that are products of Canada, Executive Order 1419-3. All articles that are products of Mexico, 1419-4. All articles that are products of the PRC, 1419-5. If leverage were all it took to establish a reasonable relation between these means and the particular emergency of trafficking, means and test would be trivially easy to pass. In so holding, the court does not pass upon the wisdom or likely effectiveness of the president's use of tariffs as leverage. That use is impermissible, not because it's unwise or ineffective, but because Section 1701 does not allow it. Rather, the trafficking orders' clear misconstruction of 1701's deal with condition renders them actions outside delegated authority. Soon after joining the Supreme Court, Justice Story declared, oh, I love Justice Story, declared invalid a proclamation by President Madison. Wait, hold on. Say what? That revived an embargo on trade with Britain and France in the Non-Intercourse Act of 1809. Oh my goodness. The proclamation lacks statutory authority because it relied on an expired embargo provision in the Act. The young justice's account of the judicial role in that case applies undiminished today. Here's our quote. All right. Quote, Justice Story. I take it to be an incontestable principle that the president has no common law prerogative to interdict commercial intercourse with any nation or revive any act whose operation has expired. His authority for this purpose must be derived from some positive law. For the executive department of the government, this court entertain the most entire aspect, and amidst the multiplicity of cares in the department, it may, without any volition of decorum, be presumed that sometimes there may be an inaccurate construction of a law. All right. It's our duty to expound the laws as we find them in the records of state, and we cannot, when called upon by the great authorities, when called upon by the citizens of the country, refuse our opinion. However, it may differ from that of very great authorities. I do not perceive any reasonable ground to imply an authority in the president to revive this act, and I must therefore, with whatever reluctance, pronounce it to have been, as to this purpose, invalid. All right, conclusion. The court holds for the foregoing reasons that IEPA does not authorize any of the worldwide retaliatory or trafficking tariff orders. The worldwide and retaliatory tariff orders exceed any authority granted to the president by IEPA to regulate importation by means of tariffs. The trafficking tariffs fail because they do not deal with the threat set forth in those orders. This conclusion entitles plaintiffs to judgment as a matter of law. As the court finds further no genuine dispute as to material fact, summary judgment will enter against the United States. So that's the win, everyone. This is the win right here, summary judgment against the United States. The challenge tariff order. Sorry, let me get some tea. All right. The challenged tariff orders will be vacated and their operation permanently enjoined. There's no question here of narrowly tailored relief. If the challenged tariff orders are unlawful, as to plaintiffs, they are unlawful as to all. All duties, imposts, and excises shall be uniform throughout the United States. And the tax is uniform when it operates with the same force and effect in every place where the subject is found. Here, and we're citing case law here, noting that the statutory and constitutional mandate of uniformity in the interpretation of the international trade laws. Here, plaintiffs' motion for summary judgments are granted, and their motions for preliminary injunction are denied as moot. Judgment will enter accordingly by the panel. Woo! All right, everybody. Oh my gosh. All right, 49 pages. Pretty nature. Oh my gosh. For anyone who's interested in this case, this is the case number here, and the judgment is here. The most important thing to remember are the 4 executive orders that have just been struck down. With that, I will go ahead and sign off for tonight. James Madison says good night. I'll be back again very soon, everybody. Take care.